The Majority Report on the phone. It is a great pleasure for me to welcome back to the program the number one talk radio, a liberal talk radio host, a progressive talk radio host in the country, author of multiple best-selling, New York Times best-selling books, and a personal favorite of mine, and in many respects, a teacher of mine. Thom Hartmann, welcome to the program.
I've been learning from you, Sam, too, for years.
That's very sweet of you to say, Thom.
And I'm honored to have you as a friend and as a colleague.
Well, thank you so much for joining us. And you have you've basically started a series of books on the hidden history, basically hidden history pamphlets, and you've come out one that is for October of this year, which frankly couldn't be more timely as we enter into the 2020 election and in trying to get a sense of, what's at stake here. And in some respects, and we should talk about this too, that, maybe we may be a little bit late in terms of the stakes. And your book provides perhaps a corrective for that, but that is you have a hidden history of the Supreme Court and the betrayal of America. I want to go through it, obviously, because you provide an extensive history, obviously, of the Supreme Court. But in what respect do you perceive it as having, when we look at the totality of the history of the Supreme Court, in what respect does it betray America?
Well, there's three kind of storylines that go through the book. The first is how the Supreme Court rose from being basically the court of last resort, a necessary and important function of government, to being the most powerful of the three branches of government. And they did that by seizing a power that was never granted them in the Constitution, and that most of the founders didn't think they had until they asserted it in 1803, and President Thomas Jefferson totally freaked out. The second fascinating piece of this that involves the betrayal of America is how the Constitution explicitly says in Article 3, Section 2, that the Supreme Court not only is to be regulated by Congress, and that would be as to how many members it has, and when they meet and what their budget is and where they meet and all that kind of stuff, but also that Congress can pass legislation and put specific exemptions into that legislation on which the Supreme Court may not rule. So Congress can pass a law. This is called jurisdiction stripping or court stripping. It has happened in our history. Congress can pass a law, and they can build into that law a sentence that simply says the Supreme Court may not rule on the constitutionality of this. And Congress has failed in that regard in a big way. And then the third is the politicization of the court, which really started in a big way with the Nixon administration. In 71, the Powell memo, and then in 72, Nixon puts Lewis Powell on the court, and then 76 and 78 in the Buckley versus Vallejo decision, and then the First National Bank versus Bellotti decision, which Lewis Powell authored. The court rules in 76 that if a billionaire wants to own a politician or throw hundreds of millions of dollars into a political campaign or for lobbying, that cannot be regulated by the government. It overturned a whole bunch of good government laws that were passed literally from 1907 right up through right after the Nixon bribery scandals. And then in 78, in the First National Bank case, they applied that same logic to corporations, and then tied it all together in a neat little bow in 2010 with Citizens United. So we've got, and so as the court acquired this power, and as it gave this power to wealthy people and corporations, the Republican Party, in large part, in part because of their shock over the 1954 Brown versus Board decision and the 1973 Roe v. Wade decision, decided that they were going to get control of the friggin' Supreme Court. We're going to take this thing back. And they did it by rigging presidential elections. And in the book, I document how Richard Nixon committed treason to become president in 68. by blowing up Lyndon Johnson's peace deal with South Vietnam. Everett Dirksen, the Republican leader at that time, acknowledged it was treason. We didn't hear the tapes of this until 50 years after LBJ died, but they're out there now. How Ronald Reagan committed treason in 1980 to become president, cutting a deal. We now have the testimony of the then president of Iran, who said that the Reagan campaign approached them and said, if you guys will hold on to the hostages until November, until the elections. Actually, they held on to them until January. They released them to the second, the minute that Ronald Reagan put his hand on the Bible to be sworn in. If you guys will hang on to the hostages, so Carter is humiliated, we'll make sure that you get all the spare parts and weaponry that you need, because they were, they had an all-American military infrastructure, and the Shah had just been overthrown. And then how George W. Bush, his daddy, had several friends on the court, and they went to bat for George, stopping the recount in Florida in 2000, a recount that when the New York Times actually did it a year later, they found, sure enough, Al Gore actually won Florida. And then, the failure of the court to be involved in anything having to do with Russia involvement now, and the corruption of the court by Mitch McConnell holding off on Barack Obama's nomination of Merrick Garland for almost a whole year. This is unprecedented, unconstitutional, and frankly, I think criminal. But the court was just fine with that. So the court has become essentially, as Sheldon Whitehouse pointed out in an op-ed in last week's Washington Post, an arm of the GOP.
And we should say, just that Whitehouse and a couple other senators, that letter, an op-ed that he wrote, and I think they wrote a letter as well to the Supreme Court with about 4 or 5 other senators sign off. It was in the context of Second Amendment cases, but it was, as far as these things go, almost a threat, right? This is a precursor, and I don't want to get ahead of ourselves, because I think there is a very, very strong movement, and your book is part of sort of the intellectual case that is being developed now, so that lawmakers are compelled to do something in the event that Democrats have the ability to do something, after the 2020 election. But let's go back to 1803 rather, and talk about how the court changed here. And I have to say this too, that one of the things I think that is clear is that a lot of what we're seeing with the court today is it's reverting to where it has traditionally been, right? Like the court has always been, certainly like in the lead up to the Civil War, and really in a dramatic fashion, I think, during Reconstruction and then throughout Jim Crow, the court really functions, and we could talk about the sort of the smaller aspects of the court, or the cases that deal with different aspects of society. But from a structural standpoint, the court has intervened to make sure that it allowed the scales to be tipped in favor of powerful interests. When I'm talking about like Jim Crow and whatnot, a lot of that vote suppression, Congress may have opened the door on some level with it, with the limitations it put on the 13th Amendment, but the court certainly sort of like busted that door open and said, yes, any way you can come up with disenfranchising black voters or frankly, and poor voters, go for it. And because the court was always edifying power, largely. And then, there was we had, 30 years, I think, of the court in the mid 20th century where that was reversed for a time. But
basically the Warren Court,
yes.
Which is why the John Birch Society, with Fred Koch's money, had billboards all across America that said impeach Earl Warren throughout the 50s and 60s, late 50s and throughout the 60s.
All right, well, let's go back to 1803. So when we talk about the court, just explain to us what was when the court was contemplated. And, I think there's only so much we can do, but it's important for people to understand the point of this. What was the court contemplated as being, and then what was it in 1803 that shifted its role, and how did that happen?
Well, originally, the Supreme Court was set up to be basically the court of last resort. You had to have a place where the buck finally stopped. So, if your dog ate my chicken, and one of us sued the other, and one of us wins, and then the other one appeals it, and it goes back and forth, and eventually it gets to, it keeps going up and up and up the food chain of the courts. It has to stop somewhere, and that was the Supreme Court. So the Supreme Court was considered the appellate court, the final appellate court, the court of final appeals. In addition to being the court that would adjudicate arguments between the states or between the United States and other countries. Those were the basic three functions of the Supreme Court. And as Alexander Hamilton wrote in Federalist Number 81, this is in June of 1788, he said, the authority of the Supreme Court of the United States, which is to be a separate and independent body, the power of construing the laws. Well, actually, let me jump to the next sentence. In the first place, there is not a syllable. This is Alexander Hamilton. In the first place, there is not a syllable in the plan under consideration which directly empowers the national courts to construe the laws according to the spirit of the Constitution, or which gives them any greater latitude in this respect than may be claimed by the courts of every state. In other words, the Supreme Court, in Hamilton's mind, and this is how it was sold to people in the Federalist Papers and how it's written in the Constitution, the Supreme Court is the final court of appeals, but doesn't have the power to say this is or is not constitutional, does not have the power to strike down laws, a process that's referred to as judicial review or judicial supremacy. And in fact, the part of the Constitution that specifically authorizes the Supreme Court, Article 3, Section 2, reads very simply, in all cases affecting ambassadors, this is that other area where the court has original jurisdiction. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction. In other words, it's the final appeals court, both as to law and fact, with such exceptions, and the word exceptions is capitalized, and under such regulations, and that word is capitalized, as the Congress shall make. So the court, was basically the dogs and chickens court. And in 1803, there was a case that had to do with the Judiciary Act of 1797 that, without going into a whole lot of detail, basically in this case, the court struck down a law which had been passed by Congress and signed by President Adams or President Jefferson or Washington, whichever it was. In any case, it was Washington. It was the Judiciary Act 17. I don't have the year. Anyhow, Sam, the court struck this law down, and Thomas Jefferson went absolutely nuts. He wrote. And I'll just give you a couple of quotes. These are in the book. The opinion which gives to the judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislative and executive also in their spheres, would make the judiciary a despotic branch. If this Marbury decision be sound, then indeed is our Constitution a complete felo de se, which is Latin for a suicide pact. The Constitution on this hypothesis is a mere thing of wax in the hands of the judiciary. I mean, he was just outraged. But the problem he had was that he had won the case, and so he couldn't appeal his own victory. But there was such an explosion in 1803 around the Marbury case that John Marshall, who was probably the longest serving Chief Justice in history, or one of them, never again used judicial review in a consequential way. And in fact, the court just totally stayed away from this all the way up until 1856, the second time that they used judicial review for a consequential decision. And that was when Chief Justice Roger Taney decided that he would once and for all resolve the slavery issue in the Dred Scott decision, which of course caused the Civil War, led to the Civil War, exacerbated the power, the movement toward the Civil War. So historically, the court did not decide which laws were constitutional and which weren't. Historically, the court did not strike down laws, and historically, the court did not write laws. And with those two exceptions, in the first 80 years of the existence of this country, The court never did any of those things. They started aggressively doing that sort of thing in the 1880s after the failure of Reconstruction, and picked up some steam with the Lochner Court in the 1920s, slowed down in the 1930s, and then went nuts again with the Reagan administration.
And we should say, I think the partly responsible for the failure of Reconstruction, frankly, by okaying these sort of restrictions on voting. But getting back to Article 3, Section 2, has there ever been? And so the court asserts itself and takes essentially rights, if you will, or duties that are not enumerated or granted to it by the Constitution. Is there ever a time where Congress says, hey, wait a second, under Section 2, we have the ability, and maybe this is what you're talking about in terms of like removing jurisdiction, but we have the ability to limit the Supreme Court shall have the appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as Congress shall make. Theoretically, Congress could say you don't have the ability to conceptualize the Second Amendment. You don't have the ability to could Congress
to strike down the Civil Rights Act? Yeah.
Yeah.
Absolutely.
Well, no, wait a second. That's two different things. Like, can Congress say you don't have the ability to interpret the Second Amendment? It seems to me they're on stronger footing to say you don't have the ability to, if we have if we have ratified the Voting Rights Act, Section 5. You can't. It's one thing for them to say you can't interpret the Constitution. It's another thing for them to say you can't overturn our laws, particularly if it's not, on like an explicit constitutional grounds.
Right.
I guess maybe that was their argument with Section 5, that somehow it was like a 14th Amendment. That's ironic.
It was a constitutional argument that they made when they stripped the Voting Rights Act. And it's always a constitutional argument. Sometimes they really have to shoehorn it in, but they recognize that that's the one area where they have authority, or have acquired or taken authority. But Phyllis Schlafly and I used to talk about this a lot on the air. She wrote a book called The Supremes about this. And she told me on the air on several occasions that back when Tom Daschle was the head of the Senate, that in one of the farm bills, he had included a court stripping provision, and I think it had to do with ethanol, basically saying that the Supreme Court could not challenge this law. Now, I looked for that when I was writing this book and was unable to find it, but I kind of gave up in frustration after going through hundreds and hundreds of pages of laws. But where it gets real interesting is in the early 1980s, the Reagan administration wanted to overturn two Supreme Court decisions. The first was the 1954 Brown versus Board of Education decision that outlawed segregation and overturned the 1898 separate but equal Plessy versus Ferguson decision.
I imagine John Roberts was in the DOJ working on that.
Well, we'll get to that in just a second. And then secondly, they wanted to overturn Roe v. Wade, the 1973 decision. So Ed Meese hired this young lawyer to come into the Reagan White House and gave him the singular assignment to spend a year figuring out how, without a constitutional amendment, which is typically how we've overturned Supreme Court decisions, without a constitutional amendment, could an entirely Republican House, Senate, and White House overturn these two decisions. And this young lawyer worked on this, and he came up with a rather substantial document. See, I've got it in my hands here. See how many pages it is. It's like 50. It's 26 pages. He wrote this incredible 26-page draft in which he starts literally with the founders and the Federalist Papers and the Constitution, and ends at the present moment, and says, yes, under Article 3, Section 2, Congress can easily pass a law which says that the Supreme Court may not review it. And Congress could simply pass a law saying that, segregated schools are just fine in the United States and that women do not have the power to decide whether or not to have an abortion. And that report kind of got buried. I don't think anybody's ever seen it before. I was amazed when I came across it. And it was written by John Roberts himself, who was working in the DOJ at that time, as you point out. And he's now the Chief Justice of the U.S. Supreme Court. So, the Reagan administration never did that. I mean, one of the things that Roberts points out in his report is that doing this will create, it'll be like a nuclear bomb going off in D.C., politically speaking. And, it'll provoke a constitutional crisis because no doubt the court will say, no, you can't do that. And the legislature will say, yes, I can. And there is no mechanism for resolving a dispute between the court and the other two branches. The court has claimed that they have primacy, that they have the final say in all matters. And nobody knows how that would shake out. But that's the last chapter of my book. It's titled in case of emergency break glass. Right. It's like, if all else fails, we can use John Roberts' suggestion to get around the court. Now, there's other things that are probably much less problematic, like doing what FDR tried to do in 1937, which is increase the size of the court, which has been done a number of times over the years, both increase and decrease, actually. When Andrew Johnson became president, a member of the Supreme Court died in the first few months after he became president, and he was going to appoint a new member. And Congress, which hated Johnson, I mean, keep in mind, they tried to impeach him, and Yes. They came within one vote of doing it in the Senate. Congress got together, and they passed a law saying that the number of members of the Supreme Court would go from 7, which is where it was then, down to 6. And so Johnson couldn't appoint a new Supreme Court justice. And that lasted until Johnson left office. And as soon as he left office and the next president was installed, Congress came back and added a 7th person to the Supreme Court, and that person was appointed by the next president. I'm sorry, I don't remember who followed Johnson, but whoever it was, that's what happened. And I think it might have been Ulysses S. Grant.
Yeah, and so let's talk about this. I mean, and folks should read this to sort of follow the court, which largely, again, but for the Warren Court era, has been on the side of corporate power, of established power. That may have been corporate power, moneyed power. I mean, throughout our history. I mean, like we say, the Dred Scott probably was one of the things that lit a match on the Civil War, insofar as it brought about, to head a sort of argument between the North and the South as to slavery and the expansion of slavery, and what the federal government, what rights the federal government had in regards to this, and then so as people read that, let's talk about potential solutions. Like, as I think largely this a book like this starts to set the table for people to see that we have a structural problem with the Supreme Court. I know you go through this notion, and you just talked about the number of justices on the court. Let's talk about term limits, and I'm curious from your perspective. A, what is the best result if you could snap your fingers? And then B, what is the best approach to get to that result, presuming that you don't have the ability to snap your fingers and create this type of reform?
Right. Well, in a way, what Franklin Roosevelt was proposing in 1937 was term limits. He didn't suggest that anybody would be removed from the court. The Constitution quite clearly says that during times of good behavior, which might be an interesting exception with regard to Justice Beerbong Weenie Waiver. But in any case, during times of good behavior, federal judges, whether it's the Supreme Court or any other federal judge, have lifetime appointments. It's just period. So the question isn't how do you get somebody off the Supreme Court by retiring them. The question is, how do you move them into some other federal judiciary position? And what Franklin Roosevelt suggested was that all the justices who were over 70 years old, which at that time was five of them, would become would end up with one vote. They would all become justices emeritus. Collectively, they would have one vote, and that new justices would be brought into the court to make up the missing four votes. And so that's one way to do it. They're still on the court. They just have their roles changed. They've been regulated by Congress. And that was presumably entirely constitutional. The way that is being talked about more frequently these days, by progressive activists and Democratic politicians, is saying that after a certain number of years on the court, a justice moves off the Supreme Court and back into the federal bench. In other words, they would go back, say they came out of the Ninth Circuit and went to the Supreme Court, they'd go back to the Ninth Circuit. Typically, it's the D.C. Circuit or the First Circuit. But wherever, they'd go back home where they were, but they're still a federal judge and they still have a job for life. And that you would try to do this in a way that the justices are retired in a staggered fashion, so that every president every 4-year term of a presidency has an opportunity to appoint one or two Supreme Court justices guaranteed, assuming, and that it only becomes a larger number than that if somebody dies or retires untimely. All of those are viable, Sam.
Yeah, I mean, I think Matt Ford in the New Republic had a scheme that, and I've heard other schemes that involved that notion of maintaining their lifetime appointments to the judiciary, just rotating them through different places in the judiciary between the appellate level and the Supreme Court itself. What is it about when we hear FDR's court packing? There's a lot of people who talk about it as if it was apocalyptic and it was it was an affront on democracy, and that it was very dangerous. There's definitely that sort of notion out there that, like, that's such a radical idea. Where does that come from?
That comes out of the Republican Party. That is ahistoric. It doesn't comport with the actual historical record. Although, I think I've told you this story back when I first moved to Washington, D.C. years and years ago, or, started doing our show from D.C. This is 15 years ago or 13 years ago, something like that. I was given a tour of one of the conservative think tanks, and I was down in their basement, and there was this large room with maybe 20, 30 people sitting at computers. And as I was walking around, and young people working on computers, and as I was walking around, pretty much all of them had Wikipedia up, and they were editing Wikipedia pages. Just a lickety split. And it's amazing to me in writing these books as I'm doing research. The first one was on guns. This one's on the Supreme Court. The one coming out in the spring is on the war on voting. The one I'm wrapping up right now is on monopoly. How often I find just naked right-wing bias in Wikipedia entries, whether it has to do with the Great Depression, or Smoot-Hawley, or the presidency of Franklin Roosevelt, or anything else. The simple fact is that FDR was pushing through a bunch of progressive reforms in his first term, from 1933 to 1930 to January or to March, January of 37, and the Supreme Court kept knocking them down. He passed a law that said child labor was illegal. The Supreme Court declared it unconstitutional. He created the American Reconstruction Agency. I forget the name of it, AR something, and which included long-term unemployment insurance and the WPA programs like this that provided long-term jobs to people. The Supreme Court knocked them down. And over and over and over again, the Supreme Court was knocking these cases down. And in 37, the Supreme Court was set to hear Social Security. And so America was just absolutely on edge. The majority of Americans loved Franklin Roosevelt. He was overwhelmingly popular. And he had a strong Democratic House and Senate. But the Republicans were hysterical. They were convinced that Social Security was socialism, that we had started down the road to communism, that we were on our way to becoming the Soviet Union, that long-term unemployment insurance, that child labor laws, all of these things were proof that FDR was a communist. And so FDR, realizing that Social Security was on the line, and not just Social Security, also the the Wagner Act was going to be decided in the court term of 37, which was the National Labor Relations Act, which made it legal to have a labor union. And so the stakes were like really, really high. And so FDR, knowing that the court in all probability would strike these things down, started doing a sales pitch for expanding the number of members of the court. And the blowback from the Republicans was absolute screaming hysteria. But when you go back and actually read histories of the time, and I quote them rather extensively in my book, you find that the majority of the public actually supported FDR, and he could have done it. The thing that pulled the plug on it, the reason he didn't do it, is that two of the justices, there were four justices that were that voted against him on every single case, and they could usually get a fifth one to come along. They refer to themselves as the Four Horsemen. The two of these justices changed their mind in one of the critical decisions in 37, right in the middle of FDR trying to sell his court packing scheme. And it turns out, and this was something I found in some correspondence that Frances Perkins had with her sister, turns out that Frances Perkins had a conversation with this guy's wife, and it was probably the thing that turned him. Wow. And so once that happened, the court started agreeing with FDR. They agreed with him on Social Security. They agreed with him on labor unions. And he was left with no political constituency anymore, right? It was no longer an emergency. Right. And so he abandoned his court packing scheme. He was not defeated. The way that if you read it on Wikipedia and some of this revisionist right-wing BS, what you hear is that, the Republicans successfully fought him back. No, not the case.
Well, I don't hold out a lot of hope for someone convincing Ginny Thomas to impact the future court decisions. So we may be looking at, and so from a strategic standpoint, what do you think you're advising President Sanders or President Warren?
God willing.
God willing. What do you advise them? Let's just assume that they have the Senate too. I mean, from a strategic standpoint, do you go for expansion of the court, or do you say, I'm going to threaten expansion of the court to get term limits, or the Congress should vote to narrow the jurisdiction the Supreme Court has on certain issues? What do you choose?
In 37, public opinion polling was not as well developed as it is now, but there were a number of ways to measure public opinion. And just 20 years earlier, when the Lochner Court was, striking things down or taking right-wing positions, they were still viewed as a credible and legitimate institution. By 37, the majority of Americans viewed the Supreme Court, as a political body. And the Warren Court kind of pulled that back, and really the 37, 38, going forward court, the Supreme Court kind of regained their own credibility over the years. But I think we're at that point again, where the majority of people see the court as a political agent. And so as such, my advice would be do all of the above. Propose legislation that includes court stripping provisions. Go after the court with proposed term limits, propose expanding the court. I would, assuming that and this is a huge assumption, as you know, Sam, assuming that in the election of 2020, that not only do we get the White House, but that we get a substantial majority in the House and Senate. Right. And if that's the case, then I would go for not just the cosmetic changes and not just the fight of the day. I would go for major, permanent, long-term structural change.
Well, like you said, God willing. Thom Hartmann, It is always a pleasure. We will put a link to the hidden history of the Supreme Court and the betrayal of America at majority.fm. Always a pleasure. Thanks so much, Thom. I really appreciate it.
Thank you, Sam. I always enjoy talking with you, and I really appreciate your having me on.